23 and 24 of Indian Constitution. Article 23 and 24 of Constitution provides a right against exploitation which guarantees human dignity and protects people from any kind of exploitation. Article 23, which deals with the right against exploitation, prohibits traffic in human being and forced labor. Traffic in human beings and beggars and other similar form of forced labor are prohibited under Article 23, and any contravention of this provision shall be an offence punishable under law. And further, it provides that nothing in this article shall prevent the state from imposing compulsory service for public purposes, and in imposing such service, and state shall not make any discrimination on the ground of any religion, race, caste, or class, or any other. So there are two declarations in Article 23. First, it prohibits the trafficking of human being, beggars, and other similar type of forced labor. And secondly, any infringement of the prohibition is punishable by it. Here you know that trafficking involve uh, dealing like selling, allowing, or dispose of them any like good of man or woman. It is unethical, and other use would include women and children also given unethical under Article 23. So under Article 23 clause 1, the term other similar form of forced labor has been interpreted in Dulal Samanta District Magistrate case, where Honorable High Court of Calcutta has expressed the term as a gestem generis, as it has been used either like trafficking in human being or beggar. So the mandatory service is not prohibited by public purpose as under Article 23 clause 1, and the state does not discriminate with respect of religion, race, caste, or any of the services as it imposed those services. And Article 23 clause 2 does not prohibit discrimination on its ground, and state may exempt women from compulsory service. Here I must mention one case, People Union for Democratic Rights versus Union of India. Honorable Supreme Court ruled that whatever way that is might manifest itself, Article 23(1) must strike at forced labor. So it is not only prohibits beggar but also forbids all unwilling labor, whether paid or unpaid. So if the labor is imposed upon an individual, any remuneration paid to that person would be irrelevant. And in Bandhuva Mukti Morcha case, Supreme Court observed that it is a violation of Article 21 and 23, that the state's failure to recognize, realize, and rehabilitate bonded laborer as provided for under the Bonded Labor System Act. Court ruled that Article 23 abolished bonded labor, a serious form of forced labor. Further, Article 24 prohibits employment of children. This article provides that no child shall be employed to work in a factory or mine engaged in any other hazardous employment below the age of 14 years. Here you must note that Article 24 must be read with directive principles contained under Article 19E and 19F, which protects the health of children below the age of 14 years. Further, in People Union for Democratic Rights, Honorable Supreme Court held that construction of a building is hazardous employment where children below the age of 14 years should not be employed. So you can say most of fundamental rights functions as a restriction on authority of state and imposed on the state negative duty not to interfere with the individual liberty. However, there are certain fundamental rights applicable to the word, in particular Article 17, 23, 24. So application against the state of Article 23 is not limited, but as such it strikes everywhere is encountered, and sweeping effect of Article 23 are thus vast and indefinite. So after laying down Article 23 and 24 Indian Constitution, which prohibits human trafficking and prohibits child labor, the weaker section of the society still faces some problem, but Parliament is bound to take legal action against this act. So